Hey folks, I'm attorney Andrew Branca for Law of Self-Defense. Welcome to our ongoing coverage of the Kim Potter manslaughter trial over the April 11th, 2021 shooting death of Daunte Wright in a suburb of Minneapolis when then police officer Potter accidentally used her Glock 17 pistol in place of her intended taser. Now, if you're not watching this on YouTube, I'll embed the video from the body cam of that interaction right here. If you're watching on YouTube, I'm sorry, they'll just strike the video if I attempt to embed the body cam footage. Now, this past Friday, the court under Judge Regina Chu selected the 14th and final juror for Potter's trial. 12 jurors will ultimately deliberate a verdict, with the last 2 jurors selected serving as alternates. The parties plan to meet in chambers tomorrow, Monday, with Judge Chu, meaning almost certainly no cameras, to settle remaining motions in limine on the admission or exclusion of evidence, as well as to finalize the jury instructions. Opening statements are scheduled to begin on the morning of Wednesday, December 8th. Those in the remainder of the trial are expected to be televised. And of course, we'll be covering them with live streaming and live commentary throughout the trial. This post will serve as a record of our prior coverage of the selected jurors, all the seated jurors aggregated in one place, along with the video of each of their voir dire or jury selection. First, I'll provide a general overview of the 14 seated jurors, and I'll follow that with more detailed notes and the video of each voir dire separately. Before I jump into things, I do want to briefly mention an exceptional opportunity for your consideration. Perhaps once every 12 or 18 months, we do one of our full-day Law of Self-Defense advanced classes. This is a full-day class. It's the equivalent of a law school seminar on self-defense law. It's applicable to all 50 states and taught in my usual plain English style without any confusing legalese. This class is taught live by me, streamed to you at your computer using Zoom, and there's plenty of opportunity for live Q&A with me during the class. Because we allow for Q&A, however, we have to sharply limit the number of seats available. So on the rare occasions when we do one of our Law of Self-Defense advanced classes, they invariably fill up almost immediately after we announce the date. And we've announced the date for this one. It's taking place on Saturday, January 8th, 2022. If you've ever wanted a true mastery of the Law of Self-Defense, here's the best, really among the only opportunities to grab that expertise with both hands. Again, seats are already going fast, so if you're at all interested, I urge you to grab your slot today at lawofselfdefense.com/advanced. Okay, folks, let me give you a jury summary now, an overview of the jury. Note that the physical descriptions are pulled from reports by media present in the courtroom. There was no video broadcast of the jurors during voir dire or jury selection. In terms of race, 11 are described as white, 2 as Asian, and 1 as black. In terms of gender, 7 are described as men and the other half as women. In terms of age, 3 are described as in their 20s, 2 in their 30s, 4 in their 40s, 2 in their 50s, 2 in their 60s, and 1 in their 70s. Now, juror number 2 is described as a white man, 50s, editor of a technical biology journal. Juror number 6 is described as a white woman in her 60s, a retired teacher. Juror number 7 is described as a white man in his late 20s, a manager at a Target distribution center. Juror number 11 is an Asian woman, 40s, self-described rule follower. Juror number 17 is a white woman in her 20s, a recent college graduate. Juror number 19 is a black woman in her 30s, a teacher and mother. Juror number 21 is a white man in his 40s, married with young children. Juror number 22 is a white man in his 60s, a registered nurse. Juror number 26 is an Asian woman in her 20s, in college. Juror number 40 is a white man in his 40s, an IT security consultant. Juror number 48 is a white woman in her 40s, a former IT project manager. Juror number 55 is a white man in his 50s, a cybersecurity engineer. Juror number 57 is a white woman in her 70s who served on 2 prior juries, one involving a police officer. Juror number 58 is a white man in his 30s, and his friend and his daughter's godfather is a police officer. So that's the broad overview. Let's dive now into each of these individually. So juror number 2 was the first juror seated, a white man in his 50s, editor of a technical biology journal. In questioning by Judge Chu, it was revealed that in his jury questionnaire, he had indicated he was neutral towards Potter, but also that he didn't understand why an officer would attempt to disable a driver of a moving vehicle when doing so could result in injury to others. He also felt very unfavorable towards Blue Lives Matter, perceiving it as not really an effort to offer support to the police, but rather merely an effort to undercut Black Lives Matter. In questioning by defense counsel Gray, juror number 2 indicated that he'd be prepared to judge the case based on the evidence and argument in court, and that he wouldn't do so until he'd heard the defense evidence as well as the state's presentation of their case. Juror number 2 also indicated that he didn't believe the justice system was fair, in the sense that people with greater access to legal resources will always have the advantage, and he won't get any argument on that from me. Gray wisely pointed out that in this case, that's defense attorney Gray, it was his client, the defendant, who had the more limited resources relative to the prosecution. In questioning by Assistant District Attorney Matthew Frank, who conducted all the voir dire, all the jury selection for the state throughout this process, juror number 2 indicated that he believed in the need for police reform, but that he was opposed to the notion of defunding the police, having said in his questionnaire that he strongly agreed that the police in his community help keep him safe. Next, we have juror number 6, a white woman in her 60s, a retired teacher. Juror number 6 presented as a woman of mature enough years to have 4 adult children, one of whom sadly had predeceased her, and who's a retired school teacher. Unlike the roughly 15 minutes spent on voir dire of juror number 2, questioning of juror number 6 took a full 40 minutes. In questioning by Judge Chu, juror number 6 conceded that she came to the trial with a very negative impression of Kimberly Potter, but also a very negative impression of Daunte Wright, finding fault on both sides. She also noted that sometimes the criminal justice system seemed biased, for example, in cases where the makeup of the jury did not reflect the diversity of the community. She also noted that she was aware of cases where it had initially seemed a person was guilty, where they were convicted, and then later more information is discovered and we realize the conviction was wrongful. Alarm bells went off for me here when juror number 6 described how she's a retired teacher who gets her news information and analysis from National Public Radio. Neither of those sounds favorable to the defense to me. It wasn't questioning by defense counsel Eng that we first learned that the defense intends to have their client, Kimberly Potter, take the witness stand in her own defense in this trial. I expect this is really unavoidable given how many of the jurors, including number 6, came to this trial wondering how such an experienced police officer with 26 years on the job could have failed to distinguish between her Glock 17 and her taser. Where the questionnaire suggested that perhaps police officers should not be second-guessed about decisions while on duty, juror number 6 strongly disagreed, saying their training should hold them to a high standard and failure to adhere to that standard deserves second-guessing. Hard to disagree, really. Eng followed up on this issue by ensuring that juror number 6 was prepared to be open-minded when she heard testimony on that training. Juror number 6 also expressed a strong preference for increased gun control laws. Although she appeared to understand little about guns, had never owned one, had fired a shotgun once 50 years prior and never tried it again, this could be a real problem for the defense if this were a non-police shooting, but presumably even juror number 6 would concede that police need to be armed. Curiously, when the defense was done questioning juror number 6, Judge Chu immediately informed her that she would be seated on the jury, the judge forgetting that the state had not yet had a chance to question her. As you might imagine, the state pointed out the error, and Assistant District Attorney Frank was given his opportunity to question juror number 6. Frank asked her to confirm that she would evaluate the testimony of defendant Potter no differently than she would any other testimony from any other witness, and not give Potter's testimony inherently greater weight just because she was a police officer at the time of these events. Because juror number 6 also came to the trial with a negative impression of Daunte Wright, Frank focused on ensuring that she was aware that it was Potter, not Wright, who was on trial here. Next, we have juror number 7, white man, late 20s, manager at a Target distribution center. He came to the trial with a somewhat negative view of Potter. Based on his initial view of the video of the event, he felt it was kind of clear what happened, but he also professed to be open to new information and to change his opinion if warranted. In his questionnaire, it turned out that juror number 7 claimed to have once owned a taser himself, although on further questioning it became clear that it was more an inexpensive press stun type of device, which in any case he'd had taken by Canadian Customs on a trip some years prior and had never replaced. Defense counsel Earl Gray conducted the defense voir dire of juror number 7. Here, juror number 7 was asked about his questionnaire response that he was slightly distrustful of police. He responded that this was true, but he also recognized that police have a very hard job he wouldn't be capable of doing himself, and when he needs police-type help, he himself reaches out to the police for that help. Asked about his thoughts on the criminal justice system, juror number 7 paraphrased Churchill to note that it may not be perfect, but it's the best we have. Assistant DA Frank once again conducted the voir dire for the state. This questioning didn't take long at all, and I frankly don't have many notes on it, so not much happened. Juror number 11 is described as an Asian woman in her 40s, a self-described rule follower. In a remarkable exchange right out of a lawyer joke book, Judge Chu asked her about an event described in her questionnaire in which a friend of hers was killed, as in murdered, in a fatal stabbing attack. Judge Chu then asked, did his friend recover from the stabbing? I mean, I was shocked. The judge herself had just used the phrase fatal stabbing. I'm not sure how one recovers from one of those. In any case, juror number 11 naturally answered no. And then Judge Chu then followed up with, so he or she is still in very bad physical condition? I mean, Judge, you yourself described this as a fatal stabbing. Juror number 11's response was straightforward. No, she passed away, with no apparent sarcasm in her voice whatever. Then Judge Chu seemed surprised that the friend who had been the victim of the fatal stabbing had passed away as a result. I mean, this bit was funny and brief enough that I'll embed it right here in the video version of today's content.
Now, you stated that a friend or family friend was a victim of a fatal stabbing in Minneapolis, and it was a close friend. Were the police called in connection with that?
Yes.
And were you there at the time it happened?
I was not.
Okay. How long ago did it happen?
It's been at least 5 years now.
And did this friend recover from the stabbing?
No.
So he or she is in still very bad physical condition?
No, she passed away.
From the stabbing? Okay.
Attorney Gray conducted voir dire of juror number 11 for the defense and Assistant DA Frank for the state, but nothing much came of this except they both agreed that juror number 11 was acceptable to them. Juror number 17 is a white woman in her 20s, a recent college graduate. She went through voir dire in less than 9 minutes from start to end, with the end, of course, having her seated as the 5th juror on this trial. Indeed, the voir dire was so rapid, I have few notes of interest. I did notice that juror number 17 had apparently written on her jury questionnaire that she didn't know whether the jury system was fair, and when asked about this by Assistant DA Frank, her reason for this uncertainty was simply that she didn't have enough information to know. I thought that was a perfectly reasonable position. I also noted that Frank pressed her a bit on her willingness to apply the law as the judge instructs the jury, whether she likes it or not. She, of course, agreed, and this is very normal, but coming from Frank in particular, it reminds us that the state is trying to convince the judge to give a very loosely defined recklessness instruction, one substantially lower than the normal burden of criminal recklessness. I suppose Frank wants to ensure that if juror number 17 feels ill at ease with finding criminal liability on such a low standard, she'll apply the loose instruction he's hoping for, regardless. Next, we have juror number 19, a black woman, as far as I can tell, the only black person on this jury. She's in her 30s, a teacher and mother. The voir dire of juror number 19 took substantially longer than had juror number 17, consuming a full 40 minutes. The result was the same, however, with juror number 19 ultimately being the 6th juror seated on this trial. Notable impressions of juror number 19 include that she owns both a taser and presumably firearms, the presumption based on her acknowledgement that she possessed a license to carry firearms. The taser, again, is likely not a taser brand device, but a more common, less expensive press-to-stun electroshock device, at least based on her description. Particularly interesting to me was when pressed by Assistant DA Frank on the gun matter, the ownership, where he was asking if she owned guns just for personal protection, she indicated that the guns were also useful for sporting purposes, as a hobby. In a lifetime of competitive shooting, I can say that women are far less represented in the sport of competitive shooting than many of us would like, so it's always nice to come across another one. Juror number 19 had a somewhat negative impression of both Potter and Wright based on news reports at the time and having seen the body cam video of the shooting event. She did strongly disagree with the notion that police officers should not be second-guessed about decisions made in the course of their duty, expecting them to recognize that it's a job of service to the public, a tough job, but that requires maintaining professionalism. Now, again, we can't see any of these jurors, of course, but the media reporting that Juror 19 is a black female. When asked by the defense if she would have any difficulty returning to her community if she rendered a not guilty verdict, she indicated she would not. Next, we have juror number 21, a white man in his 40s, married with young children. He would ultimately be seated as the seventh jury on this trial after only 20 minutes of voir dire. Like many others, number 21 came to the trial with a somewhat negative impression of both Potter and Wright, again based on media reports and the body cam video at the time. With respect to Potter in particular, number 21 brought a sense that her actions should have been more thought out. On the other hand, he also wrote in his questionnaire that he did not condone running from the police. I definitely got a bit of a woke vibe from number 21, although one that struck me as more passive, a result of immersion in a woke environment rather than active like a activist. For example, he had completely bought into the Black Lives Matter propaganda that there was a veritable plague of police killings of young black male suspects, when in fact such events are extremely rare outcomes of police interaction with a young black male suspect. When pressed slightly by defense counsel Gray, however, he conceded he had no factual basis for this belief, no statistics, nor studies. Next, we have juror number 22, a white man in his 60s, a registered nurse, still studying to be a nurse practitioner. After about 25 minutes of voir dire, he would be seated as the eighth juror in this trial. He came to this trial with a neutral impression of both Potter and Wright, based simply on having insufficient information to make an informed impression, and that certainly struck me as reasonable enough. He did have an initial sense that Potter had made an error, but that's hardly arguable, really. I mean, the issue at this trial is the degree of culpability, if any, for that error, not that there might have not been an error. Clearly, there was error. When informed by defense counsel Ang that Potter would be testifying and asked if he would wait to hear her testimony until forming an opinion on a verdict, he agreed that he would. On voir dire by the state, we learned that juror number 22 owns guns, but apparently only shotguns for duck hunting, a long-standing family tradition. He agreed with the statement that the police help keep the community safe, and even someone agreed that it was wrong to second-guess police officers about decisions made in the course of their duties. At the same time, he expects them to be law-abiding in making those difficult decisions. Next up was juror number 26, an Asian woman in her 20s in college. She indicated only moderate impressions for both Potter and Wright. She also had a family with strong opinions on the case, although she didn't indicate which way those lean, and she told the court she'd be able to not let family opinions influence her. To my ear, number 26 came across as fair and impartial, if strong-willed. She has a brother on active duty in the Marine Corps and believes both Black Lives Matter and Blue Lives Matter are properly just ways for groups of people to voice themselves to the greater community. Juror number 40 is a white man in his 40s, an IT security consultant. Although he spent about half an hour in voir dire, not a minute of that was by the state prosecutors, who simply passed on him, meaning accepted him without questioning. On voir dire by Judge Chu, number 40 had affirmed that he had somewhat negative impressions of both Potter and Wright, but that these would not affect his ability to be fair. He did indicate that if he learned that Potter had additional issues as a police officer, that would influence his perception of her. In terms of prior interaction with law enforcement, number 40 had a previous DWI some years earlier, but indicated that he thought he'd been treated fairly and I got what I deserved. He also had a couple of memorable stops on his motorcycle, police stops, once for loud pipes, once for riding without a helmet in a different state, and he seemed, frankly, a bit less accepting of those. He also expressed concerns about his own safety and the safety of his home and family if people were upset with the verdict, but he said he was equally concerned about such dangers in the case of either a guilty or not guilty verdict, such that it would not influence the outcome. In his questionnaire, he noted that it didn't appear to him that the initial arrest of Wright by the male officer present was being handled in as controlled a manner as it should have. He also indicated in the questionnaire that he thought Potter should have known she had drawn her pistol rather than her taser as a result of muscle memory from training and long experience as a police officer, like a driver knows which pedal is the brake and which is the gas. He also noted that Daunte Wright himself made a poor decision in attempting to get back into the car, and that he was aware that Wright was known to the police even prior to this incident. Juror number 40 himself had, while in high school, been interested in being a police officer, had participated in a police explorer activity that sounded much like what Kyle Rittenhouse had been participating in. Ultimately, number 40's reason for not pursuing a police career was the fear that he might someday be required to use his firearm. Juror number 40 strongly disagreed that one should not second-guess police officer decisions, saying anybody should be subject to having their actions reviewed. He was mostly favorable to both Blue Lives Matter and Black Lives Matter, although he didn't feel Black Lives Matter was actually achieving any tangible outcomes. He also owns a shotgun, although he'd indicated he'd not used it in some 20 years. All in all, number 40 felt like a modest win for the defense. IT people are generally accustomed to and amenable to ongoing training and education and adjusting their understanding as a result of such training and education as the field is ever evolving. And I expect there will be a great deal of use of force education offered by the defense, and jurors able and willing to keep an open mind and be informed by that education should shift in a more favorable direction towards Potter. Next up, we have juror number 48, a white woman in her 40s, a former IT project manager. She had written in her jury questionnaire that Daunte should not have died for an expired license tag. The result didn't match the crime. Asked about this by Judge Chu, number 48 assured the court that she could set that opinion aside and would be open-minded and fair. Juror number 48 had also previously protested outside a local ICE immigration facility to protest the putting of immigrant children in cages. Based on all of that, I'd bet on the defense using a peremptory strike on number 48, but they did not strike juror number 48. They declared her acceptable to them. The state obviously liked what it saw and passed on dismissing her after a very short voir dire. That brings us to juror number 55, a white man in his 50s, a cybersecurity engineer. Juror number 55 had been a machinist mate in the Navy, currently worked again in IT. This juror definitely had some interesting backstory, including having been tasered while in the Navy as part of his training as a gate guard and engaging in recreational medieval steel fights using suits of steel armor and steel weapons, albeit with dulled edges. His wife and daughter had about a year earlier been victims of a carjacking carried out by young Hispanic or black men, but he said he could separate that event from this case. He owned several firearms, including a couple of shotguns, a rifle, and 2 handguns, but didn't seem very active in any type of shooting sport. Juror number 55 indicated that he was largely neutral on both Potter and Wright, as other than seeing the body cam video once, he had no real substantive information on the event. In any case, ultimately both the defense and the state, which at this point had no more strikes, passed on juror number 55, so he became the 12th juror seated on this trial. That brings us to juror number 57, who I believe under the rules of this court will be an alternate as the 13th chosen juror. So she won't have a role in this trial unless one of the first 12 jurors is dismissed for some reason. She presented as an older white woman, again, reportedly in her 70s, who years before had served on 2 other juries, one also involving a police officer, although she recalled few details of that case. Unfortunately, the broadcast of the voir dire of juror number 57 began partway through the questioning by defense counsel Earl Gray, so it's impossible to know if something interesting was missed. What was missed, however, was unlikely to have been all that interesting to the defense, as they found juror number 57 acceptable upon hearing that she will keep the prior jury service out of mind when hearing this case and will rely on the evidence and law heard in the courtroom only. The state voir dire, as usual, was conducted by Assistant DA Matthew Frank, and it was quite speedy. Frank noted that juror number 57 had indicated in her questionnaire that she was sympathetic both to Daunte Wright for having lost his life and to Kim Potter for having lost her career in such a manner. Frank asked that the juror not consider Potter's career in this case, to which the defense objected, and Judge Chu overruled that objection. After confirming that juror number 57 would regard former police officer Kim Potter as she would any other defendant without special favor for having been a police officer, the state also passed on juror number 57, and she was seated on the jury. And that brings us to the final 14th juror, a white man in his 30s, who's one of his best friends and his daughter's godfather is a police officer. Again, I believe under the procedures of this court, number 58, as the 14th selected seated juror, will act as an alternate juror. That is, he won't actually participate in deliberations unless two other jurors are dismissed for some reason. Juror number 58 presented as a, again, youngish white male who'd seen the taser, oh, I shot him video twice. He noted in his jury questionnaire that his daughter's godfather was a police officer in a nearby city outside of Minneapolis. In terms of the effect of protest on his community, he indicated he lived far enough outside the city that he wasn't much affected. He also indicated he believed the police in his community were treated with respect. Juror number 58 strongly disagreed with the notion that decisions of police officers on duty should not be second-guessed, saying that anybody should be held accountable for what they do. He also felt that while the criminal justice system worked generally fairly, that some specific laws did impact some groups more than others. Again, ultimately, juror number 58 was acceptable to both the defense and state and became the final juror seated for this trial. Now, on Monday morning, tomorrow morning, as I record this, the parties are to meet in the chambers of presiding Judge Regina Chu and finalize the motions in limine, meaning decide what evidence will be admissible, what evidence will not, what evidence will be stipulated by the parties, and so forth, as well as finalize the jury instructions for the trial. Because these discussions will be held in the judge's chambers, it's virtually certain they will not be broadcast. It's notable that the state has been arguing for a version of the jury instructions that would allow for an involuntary manslaughter conviction even absent the traditional elements of recklessness. That is, absent the intentional creation of an unjustified risk and absent the intentional disregard of that risk. Under the traditional standard of recklessness, it would seem very difficult for the state in this case to obtain a conviction, as there appears to be no evidence that Potter intentionally created an unjustified risk of death. Hence, the state's efforts to charge involuntary manslaughter on some grounds less than criminal recklessness. The trial proceedings should be back on camera for opening statements the morning of Wednesday, December 8th, and naturally we'll be covering it live with real-time video streaming and real-time commenting of the day's proceedings and testimony, as well as a separate end-of-day analysis each evening right at legalinsurrection.com. So be sure to join us Wednesday morning about 9 a.m. Central Time at legalinsurrection.com for our live coverage of Minnesota v. Potter. Okay, folks, that's all I have for you on this case until tomorrow morning, at least. Until next time, remember, you carry a gun, so you're hard to kill. That's why I carry a gun, so I'm hard to kill. My family is hard to kill. Then you also owe it to yourself and your family to make sure you know the law, so you're hard to convict. Until next time, I remain Attorney Andrew Branca for Law of Self-Defense. Stay safe.